Welcome to Literary and Jury Charge Practice. Let's start out with some jury charge, and this will actually finish up the jury charge that we've been working on. There's just a few pages left, so we'll do this for a little warm-up. Ready? Here we go. Remember at all times, you are not partisans. You are judges of the facts. Your sole interest is to determine whether the government has proven the defendant's guilt beyond a reasonable doubt. If you are divided, do not report how the vote stands, and if you have reached a verdict, do not report what it is until you are asked in open court. 3. Juror Notes. A number of you have taken notes during the trial. Your notes are to be used solely to assist you and are not to substitute for your recollection of the evidence in the case. Any notes that you may take are not evidence. The fact that a particular juror has taken notes entitles that juror's views to no greater weight than those of any other juror, and your notes are not to be shown to any other juror during your deliberations. 4. Verdict. I have prepared a verdict form for you to use in recording your decision. Please use that form to report your verdict. 5. Duties of foreperson. I referred a moment ago to a foreperson. It is customary for juror number 1 to serve as the foreperson, and that is what we will do here. The foreperson doesn't have any more power or authority than any other juror, and her vote or opinion doesn't count for any more than any other juror's vote or opinion. The foreperson is merely your spokesperson to the court. She will send out any notes, and when the jury has reached a verdict, she will notify the marshal that the jury has reached a verdict, and you will come into open court and deliver your verdict. 6. Return of verdict. After you have reached a verdict, your foreperson will fill in the form that has been given to you, sign and date it, and advise the marshal outside your door that you are ready to return to the courtroom. Each of you must be in agreement with the verdict which is announced in court. Once your verdict is announced by your foreperson in open court and officially recorded, it cannot ordinarily be revoked. 7. Rules of conduct. During your deliberations, all the rules of conduct concerning outside influence remain in effect. After I have instructed you many times, your verdict must be based solely on the evidence presented in this courtroom. Accordingly, you are still not permitted to discuss this case with anyone but your fellow jurors, and you may not read anything in the newspapers, over the internet, or elsewhere about this case. Also, do not listen or watch any reporting about this case if it should be broadcast on TV or over the radio. 8. Conclusion. Members of the jury, that concludes my instructions to you. I ask you to remain seated while I confer with the lawyers to see whether there are any additional instructions that they wish me to give. Before you retire into the jury room, I must excuse alternate jurors 2, 3, and 4. You have been very attentive and very patient, and I want you to understand how much we all appreciate your service. I'm sorry that you will miss the experience of deliberating with the jury, but the law provides for a jury of 12 persons in this case. I have one final instruction for the alternate jurors 2, 3, and 4. I must ask you to abide by the rules of conduct until the jury reaches a verdict. That is because in the event that someone on the jury cannot continue during deliberations, it may be necessary for you to rejoin the jury. Accordingly, until the jury reaches a verdict, You may not discuss this case with anyone. You may not read anything in the newspapers, over the internet, or elsewhere about this case, and you may not listen to or watch any reporting about this case on TV or over the radio. If you would like to be advised of the outcome of the trial, please let us know, and we will contact you as soon as there is a verdict. Before the rest of the jury retires to the jury room, I must ask the alternate jurors to retrieve any belongings they might have left in the jury room. The marshal will now be sworn. Members of the jury, you may now retire. Right, that's the end of that jury charge. We will be starting another one, but first let's try some literary practice. And this is called Military Intelligence. Servicemen and women share travel insights. Ready? Here we go. Since 1988, we've presented radio shows on the American Forces Network, AFN, which broadcasts television and radio programming to U.S. embassies, consulates, and military bases around the world. Because of their experiences, our men and women in uniform are some of the world's best travelers. So in honor of AFN's upcoming 75th anniversary this May, we visited the Defense Media Authority Activity Center in Riverside and chatted with 4 military personnel. My first trip was aboard the USS Carl Vinson, says U.S. Navy Petty Officer First Class Stephen Hale. About 48 hours after we left Norfolk, Virginia, the earthquake in Haiti hit. Our ship immediately changed direction to Haiti. We cleaned out our ship store and gave the people everything we could. We took them our potable water. U.S. Army Sergeant First Class Nick Waddell speaks of learning about local cultures. I was a 20-year-old private on my first deployment to Iraq, Waddell says. We flew into Kuwait International. I'd been told don't stare at anybody. At baggage claim, I saw a woman in a burqa. I could only see her eyes. I instantly knew this was the most beautiful woman I'd ever seen. I kept staring, and I caught an elbow in the rib from one of my leaders. Their experiences have given these soldiers and sailors wisdom. If you're going to a new culture, any little bit you can learn about that culture goes a long way, says U.S. Army Staff Sergeant James Barrett, who has served in Belgium, Hungary, Italy, Japan, and South Korea. Be willing to talk to people and don't be afraid, adds U.S. Navy Petty Officer Second Class Mackenzie Adams, who served in Japan and Southeast Asia. Their travels around the world have given them a global perspective. You go to another culture and you realize those Nike Jordans really don't mean anything, Barrett says. We realized that these men and women are our country's best ambassadors. When Hale's ship stopped in Rio de Janeiro, some 40 sailors went to an orphanage and built walls, bunk beds, and a new kitchen. Then the kids all wanted to play soccer with us, Hale remembers, laughing. So these 8, 9, 10-year-old kids are playing soccer with these sailors, and of course they beat us like a drum. That was a good day in the Navy. All right, let's get back to some jury charge. And this is we'll start a new jury charge. This is a brand new one. Ready? Here we go. Mr. Foreman and members of the jury, you have heard the testimony, received the evidence, and heard the arguments of the state and the defendant. I will now explain to you the law that applies to this case. Under the Constitution and laws of South Carolina, you are the finders of the facts in this case. I do not have the right to pass upon the facts or to even express any opinion that I might have as to them, because this is a matter solely for you, the jury, to determine. As jurors, then, it is your duty to determine the effect, the value, the weight, and the truth of the evidence presented during this trial. Now, as the trial judge, it is my responsibility to preside over the trial of this case and to rule upon the admissibility of the evidence offered during the trial. You are to consider only the testimony which has been presented from this witness stand, together with any exhibits and stipulations which have been made a part of the record. Additionally, I have the duty to charge you the law applicable to this case, and as the presiding judge, I am the sole judge of the law of this case. It is your duty as jurors to accept as correct and apply the law as I now state it to you, and then reach your verdict. Finally, I charge you in this regard that you should not be concerned with what you think the law ought to be, but rather what I charge you that the law is. You are also the judges, the sole judges of the credibility, that is, the believability of the witnesses who have testified, and of the evidence which has been presented during this trial. In evaluating credibility, you may take into consideration many things, such as 1. The demeanor or manner of testifying, 2. Whether the witness had reason to be biased or prejudiced, or 3. Whether the testimony of a witness was contradicted on the other hand, or supported and corroborated on the other hand. It becomes your duty as jurors to analyze and to evaluate the evidence and determine that evidence which convinces you of its truth. While argument of counsel is a beneficial part of every trial, you should remember that the statements made by counsel are not evidence in presenting arguments. Counsel often refer to the evidence. However, you should base your verdict on the evidence as you remember it. Therefore, if there are any conflicts between the recollection of counsel about the evidence and your own recollection, you should rely upon your own understanding of the evidence. The fact that the defendant, Michael Thomas Slager, was charged and indicted in this case is not evidence in this case and cannot be considered by you as evidence of guilt in this case, nor does it create any presumption or inference of guilt. This indictment is simply the formal written instrument which contains the charge made against the defendant. This indictment is the formal document by which this case is brought into this court. The defendant has pled not guilty to the charge alleged against him. The burden is on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge you that it is an important rule of the law that the defendant in a criminal trial, no matter the seriousness of the charge, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence does not end when you begin your deliberations until it accompanies the defendant throughout the trial, until you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed around the shoulders of the defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of the guilt of the defendant beyond a reasonable doubt. All right, let's try this literary. It is called Traffic Jams. Ready? Here we go. Traffic jams, what continues to stymie autonomous car developers. Real-time traffic researchers envision an interactive environment that warns instantaneously of lane closures, suggests traffic-free shortcuts, and even paces automobiles so they never need to stop at a red light. That would require V2-1 communication, which is currently being developed. Unpredictable drivers. Autonomous cars need to be prepared for the unexpected, potentially dangerous behavior of other vehicles, such as swerving to miss road debris or running a red light. Research in improving V2V communication aims to address these situations. Intense weather, snow, rain, fog, and the light can make it hard for sensors and cameras on autonomous vehicles to identify obstacles correctly or keep a vehicle in the correct lane if road markings are covered by snow, for instance. Ethical choices, which is worse, hitting a pedestrian or swerving into traffic to avoid them. Teaching driverless cars to make these split-second value judgments is tricky business. Public trust. Computers are smart, fast, and accurate. Still, people have misgivings about handing over their keys to a robot. Only time and a lengthy record of successes are likely to change that. Some jury charge practice. Ready? Here we go. The presumption of innocence is not mere legal theory. It is not just a legal phrase. It is a substantial right to which every defendant is entitled unless you, the jury, is satisfied from the evidence of the guilt of the defendant beyond a reasonable doubt. The state must prove the defendant guilty beyond a reasonable doubt. What is reasonable doubt in the law? A reasonable doubt is a doubt which makes an honest, sincere, conscientious juror in search of the truth in the case to hesitate to act. Proof beyond a reasonable doubt must therefore be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it in the most important of his or her own affairs. Proof beyond a reasonable doubt can also be described as proof that leaves you firmly convinced of the guilt of the defendant. Now, there are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the charge against him, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt. Criminal intent is always a matter that must be determined by the jury from the circumstances surrounding the situation. All right, we will stop there. That will conclude our literary and jury charge practice.